Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to talk about three probably more interesting things to lawyers than they are to just normal folks, but they're interesting to me, so I'm going to try to explain it in a way that hopefully they will be interesting to you. The first thing we're going to talk about is the idea of a restatement of the law. What exactly is a restatement of the law? Well, we know that the law is specific to every jurisdiction. The Missouri law on torts varies widely from the Kansas law on torts. For example, in Missouri, when you have a wrongful death, the statute says that you can have all of the pain and suffering before death as well as the death, and you can recover from both of those. In Kansas, however, you only get pain and suffering prior to death if you file what's called a survival action, which essentially means the time between the injury and the time of death. So if somebody has, 3,000 pounds of concrete dumped on them and they die instantly, there's no survival action. The only thing you can get is wrongful death, and in wrongful death cases, there's no punitive damages. If you get injured because of somebody's negligence in Kansas, make sure you survive a little while. But the varying degrees of how things work between Kansas and Missouri, are just one example, are pretty much all throughout the country. There are different rules. There's different procedures. Things that you can do in one state you can't necessarily do in another. But in spite of that, there are sort of general themes in the law, and what the restatement tries to do is it tries to harmonize the law as it currently exists related to any particular topic. There's a restatement of agency that deals with agency principles. There's a restatement of contracts. There's a restatement of torts. And the case we're going to be talking about today deals with the restatement of torts. So far, there have been three restatement of torts. The first restatement, which is about 75 to 80 years old. The second restatement, which came out in 1965 and was in active use right up through 1990. And then the third restatement, which is more recent and which tries to harmonize and synthesize the law in all these different jurisdictions. And often what happens is some state will make a change in their law, as we'll see in this case. Other states will go, that makes pretty good sense. Maybe we should do that in our state. And as a result, a trend develops, and you'll see as we talk about the elements in this particular case, how the law has changed over the years. Well, the changes in the law are designed to be sort of cataloged in this restatement, and it serves as a guide to state courts. Now, interestingly enough, it's put together with law professors, and law professors are academicians, and they don't usually do very much practicing in the actual courtrooms. So a lot of the language is lofty, a lot of it is sort of prospective. This is what we ought to do as opposed to this is what's being done. And as a result, some courts ignore the restatement completely. Other courts adopt it lock, stock, and barrel. So that's the first issue. The second issue is I want to talk a little bit about the elements of duty and breach of duty in a negligence claim. Now, there's always duty, breach of duty, and damages in a negligence action. And whether something is categorized under duty or breach of duty makes a big difference in terms of how the law comes out. Duty is premised on the idea of foreseeability. In other words, if a reasonable person would foresee that harm is going to come to someone, then there is a duty to protect other people from that harm. That's the general rule. But courts don't always hew close to that rule. And one of the ways in which they don't is through something called the open and obvious exception. And here's the way that works. If you are walking across a field and somebody has not buried a cable particularly well, and a loop of that cable sticks up and you catch your foot and you fall down and you break your leg, well, that danger is not open and obvious. That's a defect in the land, and a landowner can be liable for that defect in the land. That's why when AT&T came out a few years ago to install a DSL line for me, and they left the cable laying on top of the ground, I told them they couldn't get away with that, and that if they did that, I was going to make sure that they were responsible for any dangers that arose as a result of somebody tripping over that. And for some reason, they did come out the next day and bury that line. But however, if you have a different situation, for example, somebody is walking across a field and there is a big hole, maybe 2 feet wide, 2 feet in diameter, and somebody has dug it down to 3 feet. That's a hole pretty much anybody could see. But because people get involved in conversations and they get animated in their discussions, a lot of times people don't look where they're going. And if you doubt that, all you have to do is watch people who are looking at their cell phone screen. I have seen more people screw up looking at the phone than I can count at this point. But because there is this open and obvious exception, if they walk into that 3-foot hole and break both their legs, in the states that have this open and obvious exception, there is no duty on the part of the landowner, because any doggone fool could have seen it and avoided it. Finally, let's talk about the difference between contributory negligence and comparative fault. The doctrine of contributory negligence said that if the plaintiff was in any way responsible for their own injuries, for example, failure to keep a good lookout, failure to look in front of them, they could not recover at all. If they were crossing against a red light and somebody was coming down the road at 90 miles an hour and wouldn't have stopped at the stoplight anyway and still hit them, under the doctrine of contributory negligence, they could have been thrown out of court. They could have lost on that legal point. So with the second restatement of torts, the idea of comparative fault came along. And what comparative fault does is it says if you are negligent, then your negligence is compared against that of the defendant. And on the basis of that, we award damages. So let me give you an example. You've got someone who is a cigarette smoker, and they have smoked cigarettes for 30 years, and they've damaged their lungs. And they go into the hospital, and because they're a smoker, they already have impaired pulmonary function, and as a result of that, following surgery, the pulmonologist doesn't do his job, and the surgeon doesn't do his job, and the patient dies. Well, when the malpractice case is filed, the first thing they're going to say is, look, it wasn't us. We didn't kill this person. It was the cigarettes they smoked for the prior 30 years. If somebody wants to be sued, sue American Tobacco. And in some cases, that actually works pretty well with juries. They do place the blame, in many cases, exactly where it belongs. But under the contributory negligence doctrine, they would have recovered nothing. Under the comparative fault doctrine, their negligence is compared against that, or their fault, I should say, is compared against that of the defendant. And so if the damages in the case are $100,000, but you give 40% of the fault to the plaintiff, well, then they're only going to get $60,000 in terms of their damages, because 40% of $100,000, $40,000, that's what they're going to be penalized for their own comparative fault. So with that understanding, and it's a long sort of way to go through all of this, but all three of these concepts are important in the case that we're going to talk about today out of the state of Michigan. And these are two cases that were decided by the Michigan Supreme Court. Let's take a look at them now. And it's actually two cases in one. It's Kandil El Sayed versus F&E Oil Company and Penske versus Kroger of Michigan. And it was decided at the end of July. So Alam Kandil El Sayed filed a negligence action based on premises liability in Wayne County against F&E Oil. He basically fell on the snow and ice, and he said that was a dangerous condition. The defendant moved for summary judgment, and he argued that it was open and obvious and had no special aspects, so he didn't owe the plaintiff a duty of care. The plaintiff responded that the defendant did owe her a duty of care because the condition, while open and obvious, was effectively unavoidable. So the court granted summary disposition and the plaintiff appealed. And then the Court of Appeals, Letitia, Kavanaugh, and Fort Hood affirmed in an unpublished opinion. So the plaintiff applied for leave to appeal to the Supreme Court, and the court scheduled and heard oral argument on the application, directing plaintiff to brief whether a prior case, Lugo versus Ameritech Corp., was consistent with Michigan's comparative negligence framework, and if not, what approach the court should adopt for analyzing premises liabilities cases under a comparative negligence framework. So in docket number 163430, Renee Penske and her husband, David Penske, brought a negligence action based on premises liability in the Washtenaw County Circuit Court against Kroger Company of Michigan. Renee Penske had tripped over a cable that had been strung from a checkout counter to a display basket, and the Kroger argued that it was open and obvious, and the trial court denied the motion for summary judgment. The defendant appealed the motion for summary judgment, and that's not something you can do in most states, but apparently in Michigan you can. And the Court of Appeals reversed in an unpublished decision, and so they applied for leave to appeal to the Supreme Court, and the court scheduled and heard oral argument on the application, and basically said brief it along with the other case as, we directed them to do it, brief whether Lugo versus Ameritech applies. In an opinion by Chief Justice Clement, the justices Bernstein, Kavanaugh, Welch, and Bolden held, a land possessor owes a duty to exercise reasonable care to protect invitees from an unreasonable risk of harm caused by a dangerous condition on land. And basically, Lugo's holding that open and obvious dangers is relevant to the defendant's duty is overruled. While the open and obvious nature of a condition remains relevant in the negligence case based on premises liability, it's analyzed as a part of a breach and a comparative fault situation, not duty. So, all negligence actions, including those based on premises liability, require a plaintiff to prove four essential elements: duty, breach, causation, and harm. Because plaintiffs in these cases were invitees, in other words, the business is open and it asks people to come in and do business with it, defendants owed them a duty to exercise reasonable care to protect them from an unreasonable risk of harm caused by a dangerous condition on the land. So Michigan used to consider contributory negligence to be a complete bar to recovery in the negligence action. So, for example, if you could see that there was an open and obvious danger and you just either didn't see it or didn't recognize it as a danger and you tripped over it, well, you were contributorily negligent, and that was a complete bar to relief. So the open and obvious nature of a particular danger was relevant to the court's assessment of whether the plaintiff had been contributorily negligent, not so much really to the duty. And that was based on the first restatement of torts. Neither Section 343 of the first restatement, which was about 70 to 80 years old, or the second restatement of torts, which is about 50 years old. Under the revised Section 343, landowners were still subject to liability, now categorized as invitees, only for conditions that involved an unreasonable risk of harm, and were still not generally liable for dangers that were open and obvious. Under new Section 343 in the third restatement, however, that's no longer the case. It remained unclear, however, which pieces of this fell under duty, in other words, does the landowner have a duty, or whether it fell under breach, meaning analyzed whether the plaintiff had some comparative fault as opposed to contributory negligence. So in 1979, Michigan abolished contributory negligence, and then in 2001, Lugo squarely situated the open and obvious danger in the element of duty. The third restatement, however, has since largely eliminated status-based categories in its presentation of premises liability law and created one general duty of reasonable care owed to anyone who entered a land possessor's property except for certain trespassers. And it also stated that whether a condition is open and obvious bears on the assessment of whether reasonable care was employed and does not pretermit land possessor's liability, thus situating the analysis in the element of breach rather than duty. So, reaching the conclusion that Lugo must be overruled requires an analysis of whether it was wrongly decided. First, it was wrongly decided because by conducting the open and obvious danger doctrine and any exceptions to it as part of the duty analysis, it ran afoul of Michigan's commitment to comparative fault. And by announcing the special aspects test, Lugo created confusion as to what exceptions to open and obvious danger doctrine would be. So it was a confusing ruling. Overruling Lugo would end 2 decades of uncertainty and arguments over its unclear standard and varying applications. Several aspects of Michigan's existing premises liability jurisprudence remained viable in Michigan. Land possessors continue to have a duty to exercise reasonable care. And the 3 traditional status-based categories, licensee, invitee, and trespasser, remain. The open and obvious nature of a condition remained a relevant inquiry in premises liability cases. However, to the extent prior cases have held it should be analyzed as a part of the land possessor's duty, those cases are overruled. Rather, the open and obvious nature of a danger is relevant to the defendant's breach and the plaintiff's comparative fault. This change found support from the case law and the Section 51 of the Third Restatement. Rather than conduct a narrow analysis of whether an obvious danger is effectively unavoidable or poses an unreasonable risk of severe harm, the fact finder should consider whether the possessor should anticipate the harm despite such obviousness and should do what it should do in connection with an analysis of whether the land possessor breached their duty. So the Court of Appeals judgments were reversed and the cases were remanded for further proceedings. Judge Bernstein wrote separately to suggest that the court consider how the open and obvious danger test ought to apply to people with disabilities, particularly visual disabilities, given that certain conditions of the land might be better appreciated by those with regular vision than with people who had some kind of disabling injury or condition that limited their ability to see things. And then Justice Zara dissented, and he agreed with Justice Viviano that the second restatement of torts constituted the appropriate standard for analyzing duty. So Michigan has changed the law with regard to the open and obvious analysis, and now the question is how many other states might actually go along with that analysis. So I'm going to tell you why I think Michigan got this right. And I don't always agree with the Michigan courts, and I think Michigan has some pretty screwed up rules in other places, but I think they got this one right. The idea that you could have an open and obvious defect in your land, right? A cord stretched across an aisle in such a way that someone could trip over it. That speaks to me of not so much being an open and obvious hazard as just being something that would be easy to miss. Cords are small. Not everybody has 20/20 vision. Particularly as we get older, our eyesight diminishes, and so does our coordination. Take it from me at 68. There are days when I get up out of my chair in the evening and I have to stretch before I can go anywhere. I mean, it's a situation where you lack a little bit of coordination as you get older. Of course, my Aunt Naomi used to say that coordination struck me once every 60 seconds. So I've always had a bit of a problem with keeping my nose pointed in the right direction when I'm walking. But be that as it may, the issue is just because you can see something doesn't mean that you did see something. And I would also point out that if you know that it's a hazard, and if you look at a cord that's strung up that somebody could trip over and don't perceive that as a hazard, you're not really thinking rationally, because cords account for a lot of falls, and falls are not benign after you get over the age of 65. The most common cause of hospitalizations among the elderly is either pneumonia or a broken hip. And of course, a broken hip happens when you fall over something and land and damage your bone. You damage your hip bone. So not only can it be a disabling injury and stuff that you're going to require surgery for, and you're going to walk with a walker for 6 months, it also has the potential to be so disabling that you wind up developing pneumonia and dying in a hospital. And that's not a good thing. Nobody ever wants to be responsible for killing someone or causing their death, even accidentally. And I think that most people, when they set up things like that display at the Kroger, they just don't think. And that's the purpose of the law, which is to give people a financial incentive to think, and also to place the responsibility for making things right with the person who had the last best chance to prevent the harm. And in that case, all they had to do was get one of those cord keepers that would keep the cord flat on the floor, and they wouldn't have had this problem. So I think they get that right. And the difference between analyzing it under duty and breach of duty is fundamental, because comparative fault is aimed at the breach of duty. If both parties breach a duty, one to keep a careful lookout and the other to prevent the unreasonable danger, then their fault should be compared. And when someone's looking at their cell phone and they fall into a hole, I'm sorry, but if I'm on that jury, I'm giving 90% of the fault to the person who was looking at their phone, because they had probably the best chance to avoid the problem if they had just been paying attention. There are all kinds of things that make it a jury question. Here's the problem. If you make it a question of duty, duty is a question of law, and it gets decided by a judge. And as a result, you may have inconsistent judgments in that regard. On the other hand, if you make it as a question of breach, then it becomes a factual issue where the jury has to apportion fault between the two parties. And that's a much better analysis, because it gives the jury the role that they should have there, which is deciding whether or not this danger was unreasonable in the first place and whether the fault should be compared. And again, a lot of things factor into that, not the least of which is the ability of the lawyer to make the case for the plaintiff. So I'd be interested in your thoughts on this. What do you think? Is this a good ruling? Is it a bad ruling? What are the outcomes going to be? Who is that going to affect insurance prices in Michigan? I'm sure it probably will in the short term, particularly for comprehensive general liability for businesses and that sort of thing. But with that said, I think it's much better to have this rule in place, and I wish Missouri would adopt this rule as opposed to the open and obvious, simply because it protects more people when you do that. Thank you so much for watching. I want to talk today about distracted driving. The other day, I was driving down the road. I have to travel back to Florida periodically to cut the lawn on my house in Florida. And as I came around a corner, I happened to look over at the entertainment console on my car to see what chapter my audiobook was on. And when I looked back, I had drifted so close to the center line that if I had continued looking at that thing for another 2 or 3 seconds, I would have crossed into oncoming traffic. Distracted driving is a big problem in this country, and the main culprit for distracted driving is not so much the entertainment console as it is the cell phone, and particularly people who like to text while they drive. If you don't have hands-free texting, if you can't tap a button on your steering wheel or on your entertainment console and get the car to send the text for you, pull over. Because I was fortunate. My distracted driving almost caused an accident, and that is never a good thing. So since I've learned my lesson, and I'm going to be a lot more careful, I pass it on to you as an act of kindness so that you can be careful too. Thank you so much for watching. Have a marvelous day. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.